here at 5 Dogs Range, and we need to talk about new laws. Want to do that? So I'm gonna go have a seat. Do you don't mind? So we're here at 5 Dogs Range, and here to talk about the new laws that go into effect this year. If you're not, you should be familiar with the concept of something that is called a gun violence restraining order, which is where you don't like somebody and you think they're violent, so you get a restraining order against them so that they theoretically can't hurt you because they won't have guns, except we know that people who really want to hurt you will get guns. It's had limited applicability prior to now, now meaning 2020. That's been expanded. So we have some changes that'll show up on the law this year. Shall we say have shown up. We're waiting for the Department of Justice to formulate regulations on some of it, but let's go over them. So first one is effective September 2020, so September 1 of this year, that gun violence restraining orders, GVRO, have a 5-year lifespan, possibly. So 1 to 5 years. And the subject of a gun violence restraining order could, of course, petition the court to have that shortened. But where do you think the court's going to land on that? Probably on caution, because there's not really a standard. This is not a psychiatrist has examined you and decided that you are dangerous to everyone, so therefore, or anyone. They've just got a restraining order against you. So one of the big changes is AB 61, which goes into effect September 1. So in addition to law enforcement and family members, employers, co-workers, employees or teachers of a secondary or post-secondary school are able to seek a GVRO, gun violence restraining order, against an individual subject to certain conditions. So in Colorado right now, there's a case pending where a guy tried to get a police officer to shoot him, and after the officer telling him to drop the weapon 36 times, the police officer shot him and he died. And his mama's mad at the police department. And I understand, it's a traumatic thing. It's really hard to imagine your kid would do something like that. And you wanted the police to save him. So now the officer didn't save him, and he's been cleared, and there's no problem with the shooting. It's all on video. But she sought a gun violence restraining order against the officer. So if the judge takes the cautious stance, he takes the officer's guns. He can no longer work. Colorado's law is a little different. It's a little more carefully thought out, maybe. And so the judge has the option of saying no. And there's been 1 out of, I think, 5 this year that the judges have said no. And then probably this one will be the second. But imagine you were working at your office and you and a friend are talking about going hunting, and somebody who hates you for whatever reason and wants to get back at you because they're a petty person decides to get even with you by filing a gun violence restraining order against you, and you wouldn't know who did that. They'd just file it. And you wouldn't have any choice. They would come and get all your guns, all your ammo, all your magazines, and they would take them from you. And you would have to go to court in about a month and try to defend yourself in court, and then maybe you get your guns back. And if you did get your guns back, that's going to take several months because you have to file a law enforcement gun release. It's a background check through the DOJ, and then they have to release the guns to you and the ammunition and do all the accounting. So it's a little bit of a concern in terms of basic constitutional rights. If the people who needed gun violence restraining orders against them obeyed the law, it wouldn't be a problem because they wouldn't be attacking anybody. But if they don't obey the law, they're going to hurt somebody, then the only way to stop them is to stop them. And a piece of paper seems to me to be kind of inadequate because it takes a lot of pieces of paper stacked on top of each other to stop bullets, and it's kind of heavy to carry around as a suit of armor. Steel, titanium is probably even better. So, is a gun violence restraining order proper? I don't know. Where's the due process? I think a basic tenet of our Constitution should be due process. People should have the opportunity to confront their accusers, and GVROs don't provide that, apparently. So also what goes with this gun violence restraining orders is Assembly Bill 164, which goes into effect January 1, 2020, so it's already in effect. So Assembly Bill 164 goes into effect January 1, 2020, so it's already in effect. Allows California to add to a restraining order from out of state. So all the restrictions that would take away your Second Amendment rights, that have all the other restrictions that California adds that maybe another state wouldn't add, like say Alabama or something. Well, somebody can move here with an Alabama restraining order and add all the other restrictions to it in California, and then the person would have to go to court and have a hearing to try to get that lifted in California. And it might interfere with their right to own a gun in Alabama because that gets listed on the FBI's website. Two other laws that go with this gun violence restraining order. Assembly Bill 339 requires law enforcement to develop written policies, and let me check here to get it right. Policies and procedures regarding gun violence restraining orders and make them available to the public upon request. That doesn't mean they have to publish them and put them on their website for anybody to look, but if requested, they have to develop them and they have to provide them to you, and that's as of January 1, 2020. So whatever their policies, if they're going to request a gun violence restraining order against people, they have to develop written policies and procedures for that. That's all that one is. The next one is kind of, I don't know. I don't even know why would, anyway. I'm not sure I know what Sacramento's thinking when they're doing anything. It's Assembly Bill 1430. So the next one is a bit of puzzlement. I don't even know why. I guess you could do this if you wanted. Assembly Bill 1493 allows you to voluntarily surrender your firearms under a gun violence restraining order and ammunition and magazines, which doesn't have the same ramifications, evidently. So if somebody files a GVRO against them, gun violence restraining order, they could say, hey, I'm not going to argue, I'm just going to voluntarily surrender, which evidently changes some of the ramifications. So I guess if you had a crisis, emotional crisis or something, and you slipped a gear and you knew it and you wanted to kind of make sure you didn't hurt anybody, you could voluntarily surrender, which you can do that anyway. You don't need a law that says you can do that. You can, transfer the guns to a family member or a friend. It's pretty straightforward. But I guess you could give them to the police. 1493. So, the other one that goes into effect is pretty funny. AB 879 defines something they call precursor parts, and there's some definition in the law, but it says if you're going to buy precursor parts, and that would be for people, for instance, who want to 3D print their own gun. They couldn't do that, I guess. You'd have to buy the plastic through a gun dealer. You couldn't just order them on the internet. Of course, all criminals follow the law, so I don't know how that's going to work. So if you had a 80% receiver you wanted to make into a gun, and why do people want to do that? Well, let's say the standard Glock 19 doesn't fit your hand properly, and you could pay $300 or $400 to have a Glock that you can buy on the California list contoured to fit your hand properly. They would do a grip reduction. Or for $125, you could buy a Polymer 80 kit, which is a lower receiver, and then finish the 20% of milling. It takes like 30 minutes. You can do it with a hand file. And then you'd have a Glock that fit your hand, except you can't do that in California anymore because the DOJ would tell you you have to have a serial number for that, and you have to get it through their website. and then it has to be micro-stamped. So it has to micro-stamp the rent, which doesn't exist. And it has to meet all the drop safety requirements required in the law of a regular Glock, which it can't do because it doesn't micro-stamp. So you can't get a gun that fits your hand. So if you had like really small thumbs and you needed a gun that fit your hand, you couldn't get a polymer 80 to do that because you'd have to meet all the other requirements that California imposes. Except if you have a 80% receiver you finished, you can't sell it. You're the only one who can use it. But evidently they think they're going to keep the guns out of the hands of criminals who by definition commit crimes. So now they want those precursor parts, the 80% receivers, I guess. Nobody's really defined what a precursor part is. I mean, the law kind of does. But they have to be in a face-to-face transaction at like a gun store, perhaps an ammo dealer. So this is such an emergency, it doesn't go into effect until 2024. Because it's really important that we do this. So we go into effect in 2024 because it's a crime wave of 80%. You'll hear the key phrase ghost guns. Nobody really knows what that is. You can actually see them. They're not like a ghost. They're not invisible. They just don't have serial numbers on them. Well, it's illegal to sell a gun without a serial number on it that's older than a certain age. We already have laws on that. And the ATF, it's Bureau of Alcohol, Tobacco, Firearms, and Explosives, has regulations about that federally. So if I build my own gun, I can't sell it unless I serialize it and I register it with the Bureau of Alcohol, Tobacco, and Firearms. It has to be all done properly. Criminals don't do that. So evidently this law is only to stop regular people from building their own guns that maybe would be more appropriate for their hands or their ergonomic needs. Then criminals don't pay attention to that. Anyway, I don't know. Who knows what Sacramento's trying to do on any given moment and what their intent is. And we often assign them nefarious intent, that we think they just hate people, they hate the Second Amendment, which can be true, or they could just be ignorant and they just go on the party line. And, you know, you can check your own records as to which party is doing most of this work. Okay, Assembly Bill 1297. Goes into effect January 1, which means it's already into effect. Prior to January 1, there was a cap on how much an agency could charge to take an application for CCW. The cap was $100 for their personal fees. That's now out the window. It has to be, can we look at the words here? It says, requires licensing authorities to charge a fee equal to the reasonable costs of processing the application for a new license, issuing the license, and enforcing the license. How much enforcement do CCW really require? We know statistically people with CCWs don't commit crimes. In fact, law enforcement officers commit crimes at a significantly higher rate than people with CCWs. Statistically. Look at the data. Anyway, that's in effect. The next bill we want to talk about is a firearms transfer fee. Now I'm going to try to get this right. It doesn't really make sense, so let me look at my paper here. Starting 21 days ago, when purchasing a firearm from the dealer, current law requires individuals to pay a $19 DROS fee, dealer's record of sale fee. This reduces the DROS fee to $1 and simultaneously imposes a $31.19 fee for enforcement of the DROS to pay for the DOJ cops to come out and seize guns from people who don't have a legal ability to own guns, but they show a record of them owning guns, I guess. And we know the DOJ is really good on that because they never arrest anybody falsely except for in Bakersfield, which they've done to clients. Anyway, your fee to buy a gun just went up. Let's talk about AB 61. Now, the federal law is what sets the age limits on buying guns. So it's been the law for years that once you were 18, you could be gifted a semi-automatic handgun, revolver, pistol, whatever. And as long as you had, in the last few years, a firearms safety certificate, it wasn't a big deal. You couldn't go buy a handgun, and you couldn't buy ammo under federal law for a handgun unless you're 21. The law's changed under what we call Senate Bill 61. And that ability to buy guns when you're 18, you could have bought long guns and, rifles and shotguns. But now you can't do that if you're 18. You have to wait till you're 21. It also changes the law on long guns to be like handguns, where you can't buy more than one handgun in a 30-day period. So if you wanted to buy your grandkids single-shot .22 rifles, and you had 4 grandkids, you'd have to start 4 months ahead, because you could only buy one a month, because the law. And of course, criminals just steal them in bulk. I know somebody who lost over 100 guns in one theft. They don't have to obey the law. We have to obey the law. So now the 1 gun a month applies to any semi-automatic rifle. Okay? So you can't buy more than 1 handgun a month. You can't buy more than 1 semi-automatic rifle a month. Which would be like if your grandpa... No, I wouldn't apply to grandpa. Let's think of something a little bit more realistic. So let's pretend your wife's brother-in-law on the other side had an old Remington 742 semi-automatic hunting rifle, and he wanted to sell it to you, and you went out and bought it because you had to go to a gun dealer because you have to do the transfer. And then 3 weeks later you won a Benelli semi-automatic shotgun at an NRA dinner. You'd have to wait till 30 days had passed before you could register the new Benelli. Or you and your kids are going to go dove hunting in Argentina, which is a big deal, I guess, if you had the money to go do that. And you all need to take shotguns, and you were going to go buy them all shotguns. Well, they would have to buy their shotguns. You can't pay for it because that's a straw purchase, I guess, under federal law. So it's just silly because criminals don't obey the law anyway. It just means honest people would not be able to do what they wanted to do and buy more than 1 gun semi-automatic in a month. So I bought a Ruger 9mm carbine, outstanding, expect a video in the future, a few months ago. And while I was there, they had a Remington 870 shotgun. By the way, I'm doing a video on that too. And he offered it to me at a really good price if I bought both of them. But if it was a semi-automatic shotgun, I couldn't have bought them under the new law. I'd had to wait 30 days to buy the second one. I mean, I can put a deposit on it, I suppose, but they couldn't do the paperwork on it. Anyway, that's Senate Bill 61. Senate Bill 172. It's Criminal Storage of the Firearms Act, which basically says you can't leave guns around where children are likely to get access to them, or crazy people, people who danger themselves or others, or people who are prohibited from owning guns. So like if a friend was coming over and they're a felon in that they committed a crime 30 years ago, but then they got the love of Jesus and changed their life, but they never went back to see if they could get the felony reduced, and they came over to your house and you had a shotgun sitting in the corner and they had access to it, technically you're at fault because you gave them access to it. Or somebody who's a danger to themselves or others and then hurts themselves or takes the gun to a school and waves it around in a rude, angry, or threatening manner in any public place, or child who hurts themselves or other people with a gun. That now, that conviction for that, if you were convicted of giving them access to the gun, would include a 10-year prohibition on the owning of any guns. So you're exempted from that if they broke into the house and stole the gun. If you kept the gun in a locked condition, you kept it locked in a way that a reasonable person believed it was secure, in a safe, you put a state-approved trigger lock on it, you're exempt. But the new law also imposes specific firearm storage requirements for residential care facilities for the elderly, residential care facilities for people with chronic life-threatening illnesses, and community care facilities for adults under the social services. Okay. If it just means that grandpa is going into a home because he needs some assisted living care, but he's still okay and he still likes to go out to the range once a month and shoot, but he can't leave the gun at my house because I don't have a way to store it, but he wants to take it to his assisted living, well then they would have regulations on how they have to store them. Okay, I get that. I don't even necessarily object to that, as long as it's reasonable and doesn't prevent the person who's of sound mind from owning the gun. The scary thing is that if somebody did get access to it and they did hurt themselves, even though you tried to keep it up and keep it away, and you're convicted of that, you allow the person to have access to the firearm and they hurt somebody or themselves, that conviction means you have to dispose of all your firearms and can't even touch one for 10 years. And not even around ammunition. Just FYI. Okay, sorry. Which brings us now to Senate Bill 376. I want to get this right, so I'm going to read it. Current law defines infrequent sales of firearms as less than 6 handgun transactions per year, and as applies to long guns, the current law as applies to long guns, current law allows occasional and without regularity sales of long guns. Sales in excess of that requires a California firearms dealer's license, CFDL. This bill redefines infrequent to now mean less than 6 transactions per calendar year, regardless of the type of handgun or firearm. And in any event, no more than 50 total firearms per calendar year. I don't know what that means. If you had a family member who's a collector, then you're going to make sure a dealer has to go through and do all those sales. I mean, that's the way it has to be anyway. But does that mean you can't consign the guns to a dealer, or you can't move them out of state to an auction house, which is what a lot of people do? It's a good way to get high dollars for the guns. I don't know. So if you're going to sell less than 6 guns a year, you're okay. If you're going to sell more than 6 guns a year, that's a problem. Now, I know, I'm a guy who sells guns, right? Well, sometimes, I just sold a collector's item. I'll just give you an example. Well, why? Because I wanted to invest in some of the other collector's items I already have in repairing them and bringing them up to preserving them so that they're in better condition, so they'll be more valuable 20 years from now. My kids might have to sell them, so they should be in good condition. I mean, I think I have a little bit of a moral responsibility to pass something down to them. That's a personal feeling. You know, your mileage may vary, but so I would like it to be in good condition when they get it. So I sold it, but I reinvested it into the guns. So tax purposes, it's still all reinvested, I suppose, if it matters. But what if you had to sell them because you lost your job, or, grandma needed an operation, or well, how do you do that? I don't think anybody really knows. I know you can consign the guns. You can take them to a dealer who does consignments, and they'll put it for sale, and they'll handle the whole transaction, and they get usually 20%, although sometimes you can make a deal if everything's in good condition and you do a lot of the work to get it that way. Maybe for a little bit, they get a little bit less of a percentage. But they're going to have to hold it for a certain amount of time before they can even sell it, and then they're going to sell it, and you'll get your percentage when the thing's paid off. You don't have to handle any of the transaction. I think it's probably a better way to sell them anyway. But I think what they're targeting with this, honestly, is police officers who buy the gun, off-list gun, and off-roster gun, and then they turn around and sell it for twice what it's worth. So the law now changes. You can only do that less than 6 times a year with all guns. It's all about limiting what we can buy. It's not about honest people engaging in transactions. The Bureau of Alcohol, Tobacco, and Firearms has a set of rules for people engaging in the business of firearms, and they'll get you on the federal law if you exceed their rules and regulations. So I'm not sure California has to do that, except California is in the business of limiting Second Amendment rights, so that's what they do. It's not even really a question. So again, if you object to any of this, that's between you and your own conscience. You should look to see who's voting for what. It's primarily one party engaging in this. I know there's a lot of people upset at the current governor, Governor Newsom, right now, and they're engaging in a recall campaign. I've seen people out collecting signatures for that. So, there's lots of ways to do this besides breaking the law. I wouldn't engage in violating the law, ever. just be super cautious, know the law. The Department of Justice has firearms updates on their website and their forms of publications. I'll see if I can link that in the description. We would invite you to like and subscribe to our channel if you like what you see. If you don't like what you see, let us know. Be kind, please. Anyway, and we look forward to seeing you soon in class. And maybe the bright sunlight in the middle of January is a pretty awesome thing because it's green and it's January and you don't have to wear a jacket. Wonderful weather. Take care, get out to the range more, you know you like it. And when you come out here, you wish you'd come out more often, so just make it happen. Once every 90 days or less. So never stretch it past 90 days because it's a fine motor skill and biomechanically you start to lose it. So get out there, have a good time, take your family, teach your kids safety, and we'll see you on the range.